appeal in the name of Sicwebu and Secretary of State for the Home Department.
Please you, my ladies, I appear on behalf of the appellant in this matter, my learned friend, Mr. Malik KC, on behalf of the respondent.
Yes.
Hopefully there's no need for us to go through too much housekeeping, given that things should be in reasonable order.
Ship-shape order. We've
that's
read the
promising.
material.
I'm very grateful. Perhaps, given that we're live streamed and for my own mental note, it's worth reminding that there is no anonymity direction in this case. However, I certainly will be endeavouring to refer to the children using their initials.
That's fine. N and S.
Yes.
Yeah, and the younger daughter we might refer to
may or may
as
not
the
be.
baby.
Yes. And I should also make clear and apologise on the appellant's behalf. He is running late, so he will be tumbling in at some stage, and I apologise for any inconvenience. His wife will also be coming along with the baby, but they, of course, will be sitting outside of court.
Right. But you're happy to start without
I
the
am,
baby.
my lady, yes. The only factual correction I respectfully wish to draw to the court's attention appears in my learned friend's skeleton, and it's no doubt something that he's already recognised. And in paragraph 10 of his skeleton, he refers to another child, OM, being born. So this is a son of the appellant from another relationship, and the respondent provides a date of birth of the 12th of December 2017. That is wrong, it should be 2007. So OM is now around 15, 16.
Sorry, could you give me the date again?
2007 rather than 2017.
So
that relationship predates the
Yes.
relationship with the wife.
yes, and OM didn't live with this family.
No,
did it?
no.
So just so we're really clear, N, we've got her birth date, we've got S's birth date, and then the baby.
Yes.
Can you just give me a birth date? Was it December?
It's the 18th of December 2020.
Yes.
So
So she's now.
nearly 2. It's set out in my skeleton just behind paragraph 26.
Yeah.
She's already 2 plus, isn't she? December 2020?
Yes. Yes,
2 and a bit.
apologies. My maths is appalling. Yes.
Mine's not very good. Anyway, that one we can sort out.
Yes, yes. My ladies, you will see that there is one ground
Yep.
advanced in 3 ways. And if I may, I propose to rattle through each of those 3 ways in the order in which I take it in my skeleton. Mindful, of course, that the test for you is whether or not the Upper Tribunal decision was wrong.
Wrong in law.
And whether there is a point of law arising from the decision. So the first ground is characterised as a failure to take into account material factors.
Yeah.
And the starting point there is the First Tier Tribunal decision from 2018, there being 2 FTT decisions in this case.
Yes.
And there it was found that it would be unduly harsh of a wife and children to have to relocate back to South Africa, the GO limb as it's sometimes called.
Yep.
And following that, there was further submissions made relating to the extent of rehabilitation, and then the Secretary of State made a subsequent decision, which is the subject ultimately of this appeal, and in that, the Secretary of State accepted that it would be unduly harsh for the children and the wife to have to go to South Africa. That's page 123 for your note. And it's page 110 for your note, which paragraph 113, which is the First Tier Tribunal's determination on that GO limb. So the issue then is just about whether it be unduly harsh, pausing there whilst my appellant settles himself. The issue, and it's my solicitor who sits behind me, of course. The issue is whether it be unduly harsh for the wife to bring up these 2 children, now 3 children, by herself. Would that be unduly harsh? And if we can pick up the judge's reasoning at paragraph 32.
We're now in Judge Hanson's decision.
In Judge Hanson's decision, yes. So tab 16, page 183.
Yeah.
And we can see in paragraph 32, the judge assesses that the best interests of NS, the elder child, lie in favour of her remaining in the UK and to continue receiving the treatment she requires to improve her mental health. In my submission, arising out of that, an obvious and important factor for the judge to consider when considering the stay-in was the extent of the available support for the wife. And to put it bluntly, in my respectful submission, there is no consideration of the available support network for the wife. It is right that the judge quotes a number of paragraphs from the wife's statement. We have that just before.
Yep.
Paragraph 29, and in particular, indented paragraph 4, so on page 180.
So my page numbering is different from yours. So,
Oh, that's regrettable.
so which paragraph?
I'm looking at
29. She talks about when the appellant was in prison.
I'm looking at paragraph 29 of Upper Tribunal Judge
Yep.
Hanson's judgment.
Disaster for me. No way I can raise them on my own. Mother and siblings not able to assist me. So no support, she says.
Yes, yes.
So did you say there was another paragraph that we should look at?
Well, if we just pause there, I accept, of course, that the judge recites that paragraph in his judgment. But the question is the extent to which the judge has then gone on to critically evaluate that available or non-available support network as a factor in the assessment of undue harshness. And in my submission, the judge simply hasn't gone on and done that. Merely copying and pasting passages from a witness statement, or even not copying and pasting passages, is not the point.
Well, you say copying and pasting, which sounds a little...
I don't mean to be dismissive.
It sounds a little dismissive.
Yes.
But I think what the judge is doing is identifying the relevant paragraphs.
Yes.
And putting those in. He hasn't simply cut and paste the whole witness statement.
No. And
He's identified those paragraphs that say something that he thinks is relevant.
Yes.
I'm assuming Judge Hanson is a he.
He is.
Yes, good. But you say, nonetheless, he didn't evaluate it when
Exactly.
He did. Okay.
The judge, I would accept, begins to touch on what could be described as an evaluation of the available support network in paragraph 37, which is a paragraph I will come on to in more detail in due course. It's the COVID paragraph.
Yes.
Where it begins, although as a result of COVID-19, AM has come to depend on MS for support with regards to the school runs, I find the evidence fails to support a finding that the degree of dependence from MS's wife and children and the consequences, so his not being able to assist as he has to date, is such that it will result in unduly harsh consequences. So there is some consideration there of the degrees of dependency that MS's wife has, and it's being described that Mrs. Sicwebu constitutes an available support network who won't be there. But what there isn't is an evaluation of who else may be able to step in place, or the fact that there is no one.
But it isn't, well, isn't he proceeding on the basis that there isn't anyone else? Because he's referred to it in the witness statement. Or do you say he forgot that?
Yeah, I say he failed to take into account that as a material and relevant factor. If it was a material and relevant factor, then one would expect some interrogation and analysis of it, not simple recitation. Some evaluation or weighing up. And that is what is missing. Because her case is that she is genuinely worried about how she will practically and emotionally cope looking after her 2 girls, and of course a newborn, her being 6 months pregnant at the time she appeared before the judge. We've looked at the paragraphs which the judge included. It's perhaps, if I may, worth looking at the paragraphs that the judge didn't include. Yep. And I don't, I'm not making the point that the judge should have included everything. That's not my observation. My observation is the extent of the evaluation that's arisen. But if I can invite you to open the supplementary bundle, the first supplementary bundle, and take you to page 20.
I've got a slight systems failure here that I haven't got my supplement with me.
That's quite all right. It's a short point. I'll simply...
Could you? I can get them electronically, but if you could just read out the short point, that would be
Yes,
great.
of course. So we've seen how the judge recited paragraph 4 of the partner's statement. Paragraph 12 in my submission is directly pertinent to one of the key issues. And it's in paragraph 12 that the unchallenged evidence of the wife is, if my husband is deported, I do not know what will happen to me and my children. We will not be able to cope mentally and physically because of my poor health and under the new normal of the COVID-19 pandemic, bearing in mind that I've been classified as COVID-19 at risk. So front and central of the appellant's case is that his wife doesn't know how she will cope mentally or physically. And that's why the availability of any support network was a really critical feature to be engaged with. And save for the recitation of paragraph 4 of the statement, in my respectful submission, we don't have any proper evaluation of the impact of the absence of any available support network.
How were they surviving financially? What was the wife working? Is she working? Is she able to work? There's nothing in the statement about it, is there?
No.
Well, paragraph 10 says she can't
No,
work.
he's the breadwinner.
He's
Yes,
the
it
breadwinner. I cannot work.
Yeah.
So I assume they're relying on benefits. It says we are now relying on benefits.
Yes, it does. Thank you. And that paragraph, was that paragraph cited by the judge? 7.
No.
No.
So there were real question marks about how practically and emotionally the wife was going to cope by herself. And in my respectful submission, there should have been alarm bells ringing because of the history that the wife had given about her father having recently passed away, her brother having committed suicide, her mother being a widowed pensioner with her own health problems. One brother suffers from severe epilepsy and lives at home with his mother. The other brother has 2 children with significant special educational needs, global developmental delay, and autistic spectrum disorder. All of these are unchallenged facts set out in the mother's statement. And yet nowhere have they been given any, in my submission, adequate consideration.
There's recited as facts, I think, in the Upper Tribunal, aren't there? I mean, those aspects are known.
I'm not sure.
UTJ.
They were certainly known, but I'm not sure to what extent they are recited as facts. Save what we have in paragraph 29 and what's set out there. just reminding myself, and I don't think that I'm omitting anything, but no doubt
Okay.
Mr. Malek will correct me.
Yep.
So in my submission, the judge doesn't consider the extent of the available support. What the judge does instead is to say, well, you managed when he was in prison, so I consider that you will manage again. But respectfully, there are 4 problems with that approach. First, it fundamentally overlooks that N, the oldest child, suffered significantly whilst her dad was in prison. It's not just a case of them managing and things being sweetness and light whilst he is in prison. On the contrary, N suffered, in my submission, significant harm and long-term harm. She suffered from speech delay, and we have that from the psychologist report, which I shall take you to in more detail in due course. And that speech delay was at a time when she was 5 and starting school, not a toddler. I'm not for a moment suggesting that any of this means that Mr. Sicwebu should not have been imprisoned for his offending.
No.
That is obviously a given. All I am highlighting is that when Mr. Sicwebu was in prison, it was not a pain-free period for this family. And that is why I say the judge has erred by effectively saying you managed before when he was in prison, so you will manage again. They didn't manage. There was harm done, which has potentially long-term consequences. See the diagnosis of separation anxiety disorder, which subsists. It wasn't just a question of speech delay. It is also the separation anxiety disorder. Perhaps if I could take you now then to the psychologist's report, which is in supplementary bundle A, but I shall simply...
Okay, right.
So, page 44 of the supplementary bundle. So we're in here the appellant's bundle as it was before the Upper Tribunal.
Yep.
And page 44 is an internal page of the psychologist's report.
And you're looking at the printed numbering, not the...
I'm looking at the printed numbering, which also matches, as it happens, the handwritten numbering, I think.
No, it doesn't on mine.
Oh.
It doesn't matter. Mine's got 41 and 44.
I see.
Doesn't matter.
Sorry, I was reading the 1 as a 4. Yes, apologies. The printed numbering
Yeah.
I'll be using in this.
All right, so this is Ms. Licht's report.
It is. And we can see that in the paragraph at the top, beginning in my opinion, the expert considers a degree to which the wife will be emotionally unavailable for her children. Mrs. Sicwebu is currently undergoing a period of bereavement. Given that she indicated that she finds it hard to play with her daughters due to a medical condition, she may not be able to take part in some activities that a girl of N's age would enjoy and benefit from. Then in the next paragraph, I'll allow the court to read these to yourself, but just to paraphrase, the next paragraph describing difficulty N has in making friends. Paragraph after that, we can see how N's presentation is affecting her ability to learn and to concentrate. It's been impaired due to moderate anxiety levels. And then in the paragraph just above diagnosis, it sets out how N is presenting with symptoms similar to those of someone with dyslexia. It's recommended to first assist N with managing her anxiety. Once this is settled, notice if the dyslexia symptoms are present, and then assess it. And then in the last sentence there, 3 lines up from the bottom, symptoms of separation anxiety disorder, anxiety and low mood may better explain behaviours, but sometimes may also be seen in individuals diagnosed with autism. So She's presenting with social difficulties. She's presenting with educational difficulties. It may be that there is underlying dyslexia or autism, but the current view is that actually the etiology of those is from a separation anxiety disorder.
This is a 2019 report.
It is.
It recommended some therapies. Were those undertaken? Do we know?
Well, I can only go with the evidence as it was before the court, and the evidence is as set out in the witness statements. And, I think it's fair to say that it wasn't fully addressed or developed before the judge, so take it no further than that. And those are criticisms that the respondent and the judge, they're open criticism. They're available to them. I don't seek to look behind those. But this is still a report which was unchallenged, and the judge recognises that there is no challenge to the expertise of the author of the report. So my first attack then on this argument that she was fine, things were fine when he was in prison, my first response is to say no, things were not fine. Secondly, I say that overlooks the fundamental difference between prison and deportation. And one obvious difference is that in prison, the family can easily visit the father. But here, the appellant is quite literally going to the other side of the world, or the bottom of the world, and a single mum of 2/3 does not, in my submission, have a realistic prospect of regularly visiting the father in a way that she would do if he's in prison somewhere else in this country. And the second obvious difference is that prison represents a temporary position as opposed to deportation, which represents a far more permanent rupture to the relationship of these children with their dad. My third submission is that when the judge said that she managed okay when he was in prison, the judge failed to have regard to the physical and no doubt mental toll that prison had on the wife. She suffers from ulcerative colitis, and the evidence is that during flare-ups she suffers from significant abdominal pain, diarrhoea and bleeding, and there is a vivid incident set out in the determination of Judge O'Callaghan of where on a previous occasion she actually required a blood transfusion because of her condition. And other incidents are cited when she was unable to admit herself to hospital, even though she was feeling deeply unwell, because she simply couldn't. There was nobody else to look after her. And so we have this vicious cycle of stress and flare-ups. And in my respectful submission, that physical toll hasn't properly been accounted for in the judge's somewhat cursory, dismissive remarks that she managed okay when he was in prison. Fourthly then, and finally, in my submission, the judge has failed to have any proper regard to the additional stress that a baby would add when being thrown into the mix. Because obviously at the time the appellant and wife appeared before the Upper Tribunal, she was 6 months pregnant. The birth was imminent, child born in December. And I've already taken you to paragraph 41, where we see the birth being mentioned.
Yeah.
But in my respectful submission, it is not being mentioned in the context of what additional stress and strain is this going to cause on the family. It's a far different point which is being taken. One which, as I say, and I don't mean to sound like I'm teasing with a trailer here, but that is a point that I develop in my second ground. In the circumstances of this case, given the concerns around the availability of a support network, the fact that she was 6 months pregnant is something which, again, was crying out for a more detailed evaluative consideration. There is nothing, save that in paragraph 42, and the reference about COVID risks for pregnant women. These challenges, based on failing to take into account relevant considerations, I'm not seeking to unfairly put the judgment under the microscope and on the dissection table. They are matters which, in my submission, cried out for determination in the context of this case, where really the principal issue to be decided was, is it unduly harsh for this single mum to look after these kids by herself in all the circumstances? And we simply do not have adequate consideration of relevant factors. So unless if I can assist you further, that's all I propose to address you on the first limb. The second limb of my challenge is that the judge erred in relation to his treatment of the evidence. And again, I break that down into two parts. The first part is the treatment of Tamara Licht's evidence, a clinical psychologist, and the second part is the treatment of the COVID evidence. And given that I've mentioned the paragraph 42 so much, it's perhaps convenient if we pick that up first.
Yeah, 41.
41, I apologise.
I think it's
Yes.
accepted that this was an unfortunate reference, but immaterial, is that that's the...
I think that's the way the case is elegantly put by Mr. Malik,
Yeah.
but it's not elegant enough in my submission because it goes to a question of fairness.
Okay.
And in my submission, you cannot just brush away questions of fairness as not being material. Because what appears to have happened here is the judge has gone on and carried out his own research on the government website as to what the government says about the vulnerability of pregnant women. And that in and of itself is concerning, but where the concern really falls into material error is in the last sentence in paragraph 41, where the judge then goes on and makes criticisms and observations about the government website. Government COVID-19 website confirms that pregnant women were said to fall within the vulnerable category as a precaution, not because there is scientific evidence that as a group they face a greater risk of infection. Well, that may or may not be right, but I simply have no way of knowing what the judge has seen or is referring to.
What's the relevant? I mean, how's it...
I mean, to be honest, I struggle...
It looked...
The paragraph as a whole...
throwaway paragraph.
Yes.
Didn't factor into his reasoning or...
Well, I mean, it factors into his reasoning in as far as it appears...
No, but I mean, sorry, it's there, but he doesn't then say, because I don't regard her as vulnerable, or because it's precautionary and not scientifically based, I don't regard her as vulnerable. Or, it's just not followed through.
I find the whole paragraph difficult.
Is that right? It isn't followed through into his evaluation.
I'm not sure I could accept that.
You don't accept that. Okay.
I mean, I just can't see why else he is setting it out, unless if it features as part of his evaluation that he doesn't consider that she is vulnerable because of his assessment of the government website about the vulnerability of pregnant women. I particularly struggle with the sentence just above the one we were looking at. So the third line down.
Yeah. Not accepted.
It's accepted that the current COVID-19 pandemic is likely to pose a greater risk to her and place her in the vulnerable category, but it is not acceptance that a real risk actually exists. I just find that very difficult to understand. And
presumably your case wasn't she's vulnerable while she's pregnant. Your case was it's going to be jolly difficult. It's jolly difficult for her to manage as it is. It's going to be even harder with 3 children on her own.
yes.
And this is not just a short-term thing. This is Indefinite.
Yes, I mean, I've shown Mr. Malik. I've pulled up my skeleton to see what exactly I said on this issue in my skeleton, and to be honest, I don't really say much which is particularly enlightening on this issue. And I have precious little recollection of what I actually said some 2.5 years ago. So I speak hesitantly.
Yeah.
But this is like a central feature of this case, that she is 6 months pregnant. She can barely manage now. How can she possibly manage in due course? It is inconceivable to me that I would have abandoned that argument and just said, oh, there's a risk about COVID, but when COVID passes, there's nothing to worry about. But the problem here is twofold. It is one, the judge going away and doing his own research, which in my view is barn door obviously improper. And then two, coming back and making his own observations on what the government website actually means and saying, well, hang on, I don't actually think that they're saying that they're vulnerable because they're at greater risk of infection, but it's because of a precaution. I mean, presumably, what he is meaning there is that pregnant women have been classified as vulnerable not because they're at greater risk of getting COVID, but because there's more significant consequences that can follow to a pregnant woman, namely complications and potentially affecting the fetus. I mean, that I think is what is being said. But I mean,
hard to understand what is being said.
it's dense. It's dense, and it's made more dense by the preceding sentence.
Yeah.
And this all has to be viewed in the context of an appellant who obviously sits behind me, but who won in the First Tier Tribunal when he was present at court. And then he gets a letter in the post saying that permission has been granted, and that he is advised that there's going to be a hearing to determine whether or not there's been an error of law, and that First Tier Tribunal decision will be overturned. And that doesn't happen. There is no hearing. There is simply a paper determination by the same judge, Upper Tribunal Judge Hanson, without hearing from the appellant as to whether or not there's an error of law. Now, I don't have leave to advance any of those criticisms, but I simply couch that in the context of concerns about fairness, they are relevant factors. And so if a judge, the same judge who has done that, then goes on to carry out his own internet research, in the minds of the fair and informed observer, there is a risk of a perception of bias. And that perception is only magnified when one comes to the judge's treatment of the evidence of Tamara Licht. My ladies, I don't know if it would assist taking you to East of England Ambulance Service. That's the authority.
Speaking for myself, I don't think it's necessary, but it obviously, depending on what Mr. Malik says,
yes,
you'll be able to respond.
Yes.
Is that...
So, judge's treatment of the evidence of Tamara Licht, it starts in paragraph 39.
Yeah.
And we can see, picking it up in the middle of paragraph 39, just after where it says parenting issues, some 4 lines down. The report of Tamara Licht to a large extent sets out references to text from the American Psychiatric Association and pontificates on what might happen, rather than providing a clear indication of what will happen and the consequences of the same. Paragraph 40, there's also an issue which Tamara Licht has been criticised by a judge of this tribunal before, of referring to issues that have never been at large in an appeal. In this case, reference to risk of suicide is a further example of this, as there is no credible suggestion this was a live issue in this appeal. Well, there are a number of concerns in those paragraphs, but of particular concern is a reference to Tamara Licht having been criticised by a judge of this tribunal before. I simply have no way of knowing what criticisms the judge is talking about. If specific criticisms were being levelled against this particular expert, then in my respectful submission, the proper way of doing that would be to direct the party's attention to either a reported or an unreported decision in which those criticisms are spelled out, and then to consider and apply and importantly look at this case on its own facts and consider and evaluate the evidence of the expert. But a reference...
I mean, it's not well expressed, but isn't, and I'm not seeking to excuse the way in which the judge has dealt with it, but isn't what he's saying, let me just find the page, it's the reference to a suicide risk.
Yes.
What he's saying is, this is not a case where there's any suicide risk. She speculates about, he uses the word pontificates, which is not a very attractive way of putting it, but anyway. She says on page 45 of the supplementary bundle at 403, from a diagnosis perspective, the American Psychiatric Association indicates that separation anxiety in children may be associated with an increased risk for suicide. And what he's really doing is saying, well, that's just not helpful. It's either speculation or an irrelevant reference, because nobody is saying that there is an increased risk of suicide in this case, at least not her. So what's the point of it? And that's what, and isn't he saying that's what she's done previously? I'm not suggesting that it's acceptable, I'm just trying to understand what he's talking about. It referring to issues that have never been at large in the appeal. So referring generically to a population or a cohort of young people who experience separation anxiety and are at an increased risk of suicide, but which is not relevant in this particular case.
In my respectful submission, there is nothing improper about an expert setting out as a generality risks in relation to a cohort.
But what's the relevance of it, unless she's saying that this child is also at increased risk, which she doesn't say?
No, I accept that, but it's not irrelevant that there is a known correlation between separation anxiety and an increased risk for suicide. All the expert is doing is reciting that known correlation. Now, maybe the expert would be better advised simply not to have included that.
Yeah.
But that may be the case. But it is not a reason, in my respectful submission, for the judge to say what appears to amount to a professional criticism of the expert and the weight that should be attached to her report. And the problem is that it's couched and preceded by these unreferenced criticisms in the ether that, oh, she's been doing all this before. I'm just not able to deal with that, and the appellant is not able to fairly deal with that. And it shouldn't appear.
So if he just said, Tamara Licht raises an issue about the connection between suicide and separation anxiety, but that's not a live issue in this appeal, that there wouldn't be any reason to criticise.
I think that would be a fair observation from a judge.
Yeah.
Yes.
In a funny way, it's sort of, at least he's telling you his thought process.
Well, there is
At least you
there
do
is
know why he would come to that conclusion.
He's showing his working out, but the problem is it's illegitimate working out, because it shouldn't rely on what's being said in a corridor or what one's come across whilst eating one's breakfast. It should be, the appellant should know what the specific criticisms are and in what context in order to distinguish them. And I do take issue with the paragraphs that preceded as well, where it says that, somewhat disparagingly in my view, that what she has done is, to a large extent, sets out references to texts from the American Psychiatric Association and pontificates on what might happen, rather than providing a clear indication of what will happen and the consequences of the same. A psychologist is not able, respectfully, to always provide hard and fast evidence of what is bound to happen, there is always going to be assessments couched in terms of what is likely or unlikely, probable or improbable. And it is unfair to describe her as pontificating on what might happen in a way which, in my submission, rings as a derogatory remark. And those observations, and in particular the unreferenced criticism, are relevant because, in my submission, it has affected the judge's assessment of the weight to be attached to Tamara Licht's evidence. And it follows, by extension, that it unfairly affects the judge's assessment of weight, because he shouldn't have been relying on unreferenced criticisms, and by including that observation, I cannot exclude, or this court cannot exclude the risk that they have played a factor in the way he has then gone on to treat their evidence. Because it's an unfair criticism to say that she's just describing swathes of material from the American Psychiatric Association, when the paragraphs we've looked at in page 44 are direct and specific and pertinent to the position of N. And they are not.
Does he, when he conducts his evaluation of how the mother would cope, refer to the uncontroversial diagnosis of separation anxiety that N has and how it was affecting her in her life? He talks about assistance and interventions for N. He talks about her dealing with her emotional needs, doesn't he, at 39?
Yes.
That's the only reference. But I suppose that is the reference.
Yes, I think that's as close as we're going to get. So it may be that I could have couched that as a failure to take into account a relevant factor argument, but it's more than that in my submission here. The treatment of the expert evidence is not what one would expect.
So just to clarify, when you said you could characterise it as a failure to
yes.
take account of a relevant factor, specifically that relevant factor being N's position.
Yes. The diagnosis of separation anxiety disorder and the sequelae. So, my ladies, unless if I can assist you any further on that second limb, two issues I take with the evidence, we turn then to the third limb, which is that the judge either applied the wrong test or he applied the right test but provided insufficient reasons. And pausing there have been some skirmishes from the Secretary of State as to whether or not this is an improper ground. Do I have leave? Or leave has been granted. And it's the decision of Lord Justice Moylan, 27th of January, tab 20, page 202. Arguably, it was recognised before that. If you recall, the procedural chronology to this matter is that we were listed in December, which was day 2 of the train strikes. I, for my part, wasn't able to attend in person then. The Secretary of State, for her part, wanted further time to deal with what she said were new arguments being raised. So each for our different reasons, the hearing was vacated. But just in the hard run-up to that, there was a judicial determination that the ground 3 was within the ambit of the original ground. It doesn't appear in the bundle because that decision was rescinded after the parties reached agreement between themselves that the hearing was to be vacated. So,
right. So there's no issue about that any longer.
There shouldn't be.
Good. I can see Mr. Malik agree.
So the basis of this argument has its footing in the decision of H.A. Iraq from the Court of Appeal, and in particular paragraph 56 of that. So if I could invite you to turn up the authorities bundle and take you to page 253. So, by way of very short background, H.A. Iraq, the appellants were successful, the appellants being those who were proposed to be deported. They won in the Court of Appeal, and then the Secretary of State appealed to the Supreme Court, and we have later on the Supreme Court decision from summer last year when the Court of Appeal decision was upheld.
Yeah.
And if we turn up paragraph 56 and pick it up about 6 lines down, after the reference to UTJ Southern's decision, there's a sentence beginning, as explained above. The test under section 117C5 does indeed require an appellant to establish a degree of harshness going beyond the threshold acceptable level. So when the judge is saying, as explained above, he's talking there about paragraphs 51 and 52, if we turn back a page, where we can see in paragraph 51, what the judge is saying is that undue harsh means something more than mere undesirability. That's what we have in the second and third line. And then in paragraph 52, it's more than mere undesirability, but it's something less than very compelling circumstances, which is a test that applies for those convicted and sentenced to more than 4 years. So that's what the judge was explaining above, and then 117C does indeed require an appellant to establish a degree of harshness going beyond the threshold acceptable level. It's not necessarily wrong to describe that as an ordinary level of harshness, and I note that Lord Carnworth didn't jib at UTJ Southern's use of that term. However, I think the appellants are right to point out that it may be misleading if used incautiously. There seem to me to be two related risks. First, ordinary is capable of being understood as meaning anything which is not exceptional, or in any event rare. That is not the correct approach. See paragraph 52. There's no reason in principle why cases of undue harshness may not occur quite commonly. Secondly, if tribunals treat the essential question as being, is this level of harshness out of the ordinary, they may be tempted to find that exception 2 doesn't apply simply on the basis that the situation fits into some commonly encountered pattern. So the difficulties of talking about ordinary harshness are firstly that could mean that ordinary harshness is widespread, and so undue harshness is something which should be narrowly found, or yes, you have the points there.
It's not a comparison, and what you're looking at is how the separation will impact on that particular child and that particular family relationship.
Yes. The undue harshness
Yes.
of that. And if we turn back to the judge's approach, paragraph 35, I say he has fallen perilously close, if not committed, the lapse which the Court of Appeal advised to guard against. In the bottom of last sentence in paragraph 35, there are a large number of single-parent families in the UK. some with health needs far worse than those suffered by AM, who manage to parent their children and maintain the family unit. The judge has fallen into that trap of saying, well, there are lots of other people who are okay. It's common. What you need is an uncommon level of harshness to amount to undue harshness. That is the wrong approach. And what is particularly the wrong approach is when he says that there are those who manage to parent their children and maintain the family unit. The test for undue harshness is not whether or not you can maintain the family unit or your children are taken into care. That is not the benchmark. The test is not whether or not social services are involved. That would appear to be the approach that the judge is adopting, or certainly comes very close to adopting. And he is wrong to do so. And this is a point which is picked up in the Supreme Court decision when we have reference to a notional comparator.
I mean, sorry, can we just go back to 36? I mean, I see what you're saying, but isn't what he's saying is it may be harsh and difficult, but she will manage to the extent on his assessment that there won't be a need for intervention from social services or other agencies. He's not. I mean, is that wrong for him to have?
It is wrong in my submission. Because there is no question of a notional comparator. There is no question of a baseline assessment of ordinary harshness. There is no question of extrapolating and then saying it's okay because social services haven't become involved. In paragraph 35 and 36, by the judge saying that there is no suggestion of any need for the intervention of social services if he's deported, he appears to be using social services as some sort of placeholder to say it's not unduly harsh because social services aren't involved. That is not what unduly harsh means. So if I could just briefly take you to how this point was developed in the Supreme Court.
Yeah.
And we pick it up on page 355 of the Appellant's bundle. So the Appellant's authorities bundle, that is. Behind tab 16. And paragraph 31 at the top of the page. The context here is that the Secretary of State, in developing his appeal, was seeking to draw on observations from Lord Carnworth in KO, Nigeria, to suggest that there was a notional comparator test.
And that's what the Court of Appeal were dealing with as well.
Yes. Yeah. And paragraph 31, first, I consider that far too much emphasis has been placed on a single sentence in Lord Carnworth's judgment, and if his judgment is considered as a whole, it's apparent that he was not intending to lay down a test involving the suggested notional comparator. And then we can pick it up again in paragraph 34. Secondly, as Underhill LJ observed, this is in the Court of Appeal decision, a test based on what would necessarily be involved for any child can't be read literally. Any child would encompass children for whom the deportation of a parent would be of no real significance, despite having a genuine and subsisting relationship with that parent. So there may be those for whom it simply wouldn't matter. So for such a child, there would be little or no harshness involved, in which case the baseline level of due harshness would be very low. That is clearly contrary to the high standard which Lord Farnworth was envisaging, as illustrated by his criticism of the too low standard applied by the Upper Tribunal. And then the point is pulled out in the next paragraph. Thirdly, in recognition of this difficulty, Mr. Pilgerstoffer suggested that the appropriate notional comparator should be not merely a qualifying child, i.e. someone with a genuine and subsisting relationship with a deportee, but someone of a similar age, living circumstances, giving rise to a genuine subsisting parental relationship and nationality time in the UK. So there was an attempt to import several sensible baseline characteristics. But as the Supreme Court go and observe, there is simply the correct last sentence in paragraph 35. The suggested characteristics may be sensible, but they're an invention. So there is no such thing as a notional comparator test. One looks at the individuals and the specifics. Here, of course, we're concerned with a child suffering from special separation anxiety disorder and presenting with what appears to be symptoms of dyslexia and autism, but are more properly related to her anxiety. You don't turn around and say, it's not unduly harsh because social services are not involved. And you don't say it's okay because there are others like you and worse than you who are able to maintain the family unit. Finally, if I could ask you to turn up my skeleton argument and towards the end, paragraph 94, I say that the judge has failed to consider rehabilitation. Well, let me set the scene for that submission. The judge's treatment of rehabilitation appears right at the end of his judgment, paragraph 48. Apologies for dotting between documents. Paragraph 48. Whilst the appellant has taken up steps to deal with his alcohol problems, demonstrated an improvement since the commission of the index offence, and I've noted the emotional difficulties highlighted in the evidence and lack of any intervention having been sought by the parents to deal with the same to assist NS. I also note the availability, the same as the child will be staying in the UK. So there is some consideration in the front of paragraph 48 to the steps the appellant has taken to address alcohol problems. That is under the rubric of Article 8. We can see that because in paragraph 43, the judge says how he's moving on to consider Article 8. So he's dealt with the question of undue harshness, it would appear, found that it isn't unduly harsh, and then he has considered Article 8 more generally and rehabilitation.
Yeah.
And the question which falls for consideration is whether or not rehabilitation should actually feature as part of the assessment in the unduly harsh exercise. Is it unduly harsh to deport someone when they have taken steps to address the causes of their offending. Now, the position of the Secretary of State is that you cannot consider that in the unduly harsh test. You can consider it, for example, if you are an offender who has committed a sentence of over 4 years, the test is whether there are very compelling circumstances over and above exceptions 1 and 2. And the Secretary of State says it's at that stage that you consider rehabilitation. Well, in my respectful submission, it is odd that a more serious offender is able to take into account in an evaluation, in an evaluative exercise of rehabilitative steps, whereas a medium level offender is not. And in my respectful submission, that question of rehabilitation is something which can fall for consideration in the evaluative test of whether or not it's unduly harsh for someone to be deported. On a common sense approach, it would appear obviously a factor which could be taken into account. Common sense doesn't necessarily feature because we know, and I certainly wouldn't look to look behind this, one doesn't look at the seriousness of the offence when looking at what is unduly harsh.
So forgive me, I thought that the unduly harsh bit came into exception 2, which talks about unduly harsh on the partner or child.
Yes.
So just help me with how I'd get rehabilitation into undue harshness on child, partner or child.
Well, is it unduly harsh on a child to separate them from their father when their father has taken steps to address the offending? There is a broad common sense notion of harshness that says it is very harsh on a kid for them to be separated from their dad when their dad has done everything they could and is not a risk. And it's accepted that a more serious offender can rely on the rehabilitative element
But not
in the evaluative.
but not in the context of the exception my lady just read to you, in the context of very compelling circumstances.
Very compelling circumstances over and above exceptions 1 and 2. So there is some support for my proposition in Hesham Ali. So if I could take you back.
Just before you do,
Yes.
It would be wrong to take into account the seriousness of the offending, you said.
Yes.
Why, if it's wrong to take into account the seriousness of the offending, why is it right to take into account the rehabilitation steps?
Because it can't be right that it can be taken into account for a more serious offender, but not for a less serious offender. And what is happening in exceptions 1 and 2 is an evaluative exercise. So if I could take you to Hesham Ali, I think it does help address that. So it's page 139 of the authorities bundle. Page 139, paragraph 38, and then just above H on the left-hand margin, there's a sentence that begins, for Strasbourg jurisprudence. My ladyship has that. The Strasbourg jurisprudence indicates relevant factors to consider, and paragraphs 399 and 399A, pausing there, that is where exceptions 1 and 2 are embodied,
Yeah.
provide an indication of the sorts of matters which the Secretary of State regards as very compelling. As explained at paragraph 26 above, they can include factors bearing on the weight of the public interest in the deportation of a particular offender, such as his conduct since the offence was committed, as well as factors relating to his private or family life. So that is why I say, in line with those observations in Hesham Ali,
And that was talking about very compelling circumstances, wasn't it? The public interest in deportation can be outweighed applying the proportionality test. In very compelling circumstances, the countervailing considerations must be very compelling. Strasbourg jurisprudence, etc., etc. But you say there's a read across.
yes.
But have I got that right
I
or not?
need to remind myself of the facts of Hesham Ali.
But the sorry, I'm also a little confused because paragraphs 399 and 399A do deal with this, the unduly harsh.
They do, yes.
Yes, they do.
If I could take you to...
I think you did, if you read, I may be wrong, but I think my lady makes a good point that this is compelling circumstances rather than the exceptions 1 and 2. If you start at the beginning of 38. The judge talks about circumstances where private and family life doesn't meet the requirements of paragraphs 399 and 399A, in other words, outside exceptions 1 and 2. And then you go on to look at very compelling circumstances.
The second sentence of paragraph 38 does indicate that we're looking, at least in part, at the territory of medium offenders. Foreign offenders who have received sentences of at least 4 years,
Or
who have received sentences of between 12 months and 4 years. What this all boils down to is it's easy for this whole exercise to become overcomplicated. But what, if I could just take you in closing to a Gyarko on page 194.
so tab 10.
Tab 10, paragraph 41.
Fair balance.
Yes. So 5 lines up. Ultimately, whether the case is considered to concern a positive or a negative obligation, the question for the European Court is whether a fair balance has been struck. As explained in Ali, that question is determined under our domestic law by applying the structured approach to proportionality, which has been followed since Wang. Well, that's what this all revolves down to, whether a fair balance has been struck. And that's why I say, when carrying out the evaluative exercise of whether or not it would be unduly harsh to deport a girl's dad, it isn't inconceivable, but one can look as a relevant factor at the extent of rehabilitation. But in any event, even if I'm wrong on any of that, it can be taken into account further down the track and should be taken into account further down the track.
Well, the judge did, but he took it into account as an Article 8.
Yes. I say, firstly, he fell into error by not taking it into account at the unduly harsh stage. And secondly, he fell into error because he simply hasn't afforded adequate weight to all those factors I've alluded to in paragraph 94 of my skeleton. So the evidence from a member of a federation of drug and alcohol professionals, but he's developed the ability to change since I first met him through learning about himself, is now working on himself with regular therapy sessions to become a mature, independent and successful person. The evidence from probation, he appears to have developed techniques to healthily manage the stresses associated with everyday life. And then probation recite a list of interventions, all of which have been carried out since that 2018 determination from First Tier Tribunal Judge O'Callaghan. And one remembers that what First Tier, now Upper Tribunal Judge O'Callaghan said then is, this is a finely balanced case. What you need to do is address these concerns relating to your alcohol. That is exactly what he has gone on and done. And probation say that the sentence plan, they're agreed all the sentence plan objectives have been met. He's attended counselling. Him and his wife are communicating with one another better and are better distributing responsibilities. He's completed a brief intervention for alcohol course, engaged one-on-one with Alcoholics Anonymous and others as a key worker, fully engaged in discussions around the consequences of his offending behaviour, has completed some one-to-one victim empathy tasks. The short point is that in 2018, it was identified it was a finely balanced case. He needed to do some further work. And even there, what the Upper Tribunal Judge, or First Tier Tribunal Judge O'Callaghan did was wrongly, no criticism of him, but he wrongly weighed into account the seriousness of the offending when he did that. Yeah. And we know that that is not the right approach. One leaves that out of a balance, one then looks at what he has gone on to do, and in my submission, that is why I say there is actually fairly considered only one legitimate answer to this case. And Mr. Malik says, I'm inviting you to sit as a first instance tribunal. I'm not inviting you to do that. There have been findings made by the First Tier, not once but twice. I'm simply inviting you to make a decision on the basis of the findings the court is fixed with. And in my submission, there is no need for this matter to be remitted.
Well, we could only do that if there was only one inevitable conclusion to reach. If it's a very finely balanced case and it requires an evaluative assessment that could go either way, then surely we're bound to remit.
Yes.
Is that right?
Yes.
Okay, so unless we can say the only inevitable conclusion, we should remit.
Yes.
And do you say remit to Judge Hanson or remit to...
To the Upper Tribunal, I would respectfully suggest to a judge other than the judge.
Other than
yes.
Judge Hanson.
No criticism or discourtesy, of course, intended to Upper Tribunal Judge Hanson. Simply that in the light of some of the fairness issues which have arisen, it would appear to be a better course. The only other observation I would make is that these girls, Anne and her younger sister, have effectively been living with this litigation in the younger sister's case for nearly her entire life now. And that is after the sentence has been served. The course of these proceedings is taken twice the length of the sentence. Unless I can assist you any further.
Thank you, that's very clear. Thank you very much. Yes, Mr. Malik.
Ladies, subject to any observations, I propose to make brief submissions on the points that Miller and Friend has made this morning in the same order in which he has made those points. So Ladies will recall that Miller and Friend's first submission was that the judge gave no consideration to the issue of sport network.
Yeah.
he then submitted that there was no proper evaluation of that point. There is obviously a difference in my respectful submission between the 2 points. It is one thing to say that a fact finder has simply failed to take into account something that is relevant. It's quite another to say that that matter was taken into account, but the evaluation wasn't a proper evaluation. In my respectful submission, the judge did take into account that matter, and the judge's evaluation disclosed no error of law. Before I take you to the judge's decision, ladies, in my skeleton argument, at pages 7 and 8, this is paragraphs 20 to 26, paragraphs 21 to 26, you see that I've made 5 points. I've referred the court to 5 authorities. Now, these authorities are not in the authorities bundle. This is
They're
because
well known.
no, yes, Miller and Friend takes no issue with any of these propositions or the authorities.
Yeah.
And I do ask my ladies respectfully to have particular regard to these 5 matters. For instance, if you look at paragraph 23 of my skeleton, if a relevant point is not expressly mentioned, the court should be slow to infer that it hasn't been taken into account. Paragraph 24, a fact-finding tribunal is not required to expressly set out every step in the reasoning fully in the decision. Paragraph 25, reasons can be set out expressly, directly, or by inference.
Yes.
So with those principles in mind, if I may take you to the decision of Judge Henson, starts from page 174 of the bundle. The judge at paragraph 29 identifies the evidence. He sets out material parts of the witness statement. This is page 180 of the bundle.
Sorry, my handwriting's a bit bad, but which paragraph are
This
you?
is paragraph 29, my
Which
lady.
refers to the wife's witness statement.
Yes.
Yeah. Okay.
And you will see that paragraph 4 of that witness statement referred expressly to that particular issue, that the mother and siblings will not be able to assist. In my respectful submission, the judge clearly took that evidence into account. I mean, one can obviously say that the judge's analysis wasn't adequate, the reasons weren't proper, but in my submission it cannot, I'll address those issues, ladies, in turn, but it cannot be said that the judge did not take that evidence into account.
Well, he recorded it,
Yes.
so he was aware of it. But does that necessarily mean he took it into account?
Lady, in my respectful submission, it isn't an effective proposition that the judge expressly records the evidence, records the point, but then simply forgot when he was conducting the analysis at paragraphs 32 onwards. Now, my respectful submission is that the analysis of that point is entirely adequate.
So, but where do you say, show us the paragraphs
Yes.
that you say
Yes.
reflect him weighing up this evaluative judgment?
Absolutely. Now, before I do that, my lady, can I make this
Yes.
point that in my respectful submission, the judge records the evidence in the witness statement, and then makes findings of fact on the basis of that evidence.
Yeah.
The judge, in my submission, accepted that evidence. Now, the judges, my lady, asked me where I say that the judge considered or evaluated that point. In my respectful submission, it is over several paragraphs in the decision.
Okay, let me just understand the first point you made, Mr. Malik. So are you saying when he recorded what the wife said in her witness statement at paragraph 29, he was accepting all of those paragraphs as fact?
Yes.
Yes. And therefore not accepting the paragraphs he didn't identify? Or maybe it doesn't matter?
It doesn't matter in my
Okay.
submission.
But, so he is accepting this is
yes,
the position. Okay.
that the mother and
Facts
siblings
are-
will not be able to assist. I mean, the judge, for instance, did not say that, well, I reject this evidence.
No.
I'm not satisfied that the mothers and siblings will not be able to assist.
Yeah.
So the judge proceeded on the basis, in my respectful submission, that that would be the case. Now, if you then look at the judge's analysis, now you have seen these paragraphs earlier this morning,
That's okay.
but it's paragraph 36, sorry, paragraph 35, 36, 37, 38, 39, and 42. For instance, looking at paragraph 35, the
Sorry,
judge there...
Just can I clarify, is there any express reference to acceptance either of the whole witness statement or individual paragraphs? There's a recitation of the evidence,
Yes.
paragraph 29. Is there anything, and I know the evidence was unchallenged in the sense of no cross-examination, but is there anything that expressly says?
There isn't, my lady.
Right.
But if you look at paragraph 42, that may assist. So if you look at paragraph 42, the judge says that, well, I've considered all the evidence in the round, and on that evidence that I've cited, I accept that a deportation will result in harsh consequences. But I've conducted a holistic assessment, and I'm not satisfied that is sufficient enough to pass the threshold of unduly harsh.
Okay, so going back to the witness statement, for example, in paragraph 29, the first part of paragraph 4, which says there's no way I can raise them on my own. Is the judge implicitly rejecting that?
What the judge, in my respectful submission, is saying as to that particular paragraph is the judge accepts that this is what the mother believes. But the judge says, in my respectful submission, that that wouldn't be the case and wouldn't pass the threshold of undue harshness.
And that's you say he accepts what she says as a matter of her belief.
Yes.
But he says, well, she managed while the appellant was in prison.
Yes.
And that's why he rejects that is fact.
Yes, and also for the reasons that he gave in the next few paragraphs. For example, if you look at 36, the judge says that, well, I accept that the mother would not be able to do all the things that she wanted to do, but that does not mean that parenting will fall below the acceptable standard. There isn't sufficient dependency, paragraph 37. Uh, 39, that interventions would
So
be able.
the degree of dependency, is that emotional dependency or financial dependency? What's that about?
In my respectful submission, both. Yes, this is the physical, practical support that the husband provides. If you look at the first sentence of paragraph 37, that may assist and provide the context of the second sentence. You'll see that.
Going on school runs?
Yes.
And,
Yes.
But financial dependency, she had referred to in her witness statement, and he hadn't rejected that.
No. And as to that, milady, if you look at perhaps paragraph 39, the judge says that the children reside with a mother There's no suggestion that that will change. It's not made out that assistance and intervention will not be available if required.
So that's, you say that's the financial assistance.
Yes, and you'll see a reference to emotional needs of the children in that paragraph too. So in my respective submission, looking at those paragraphs together, it is clear that the judge did consider the point that Miller and Friends says wasn't considered. One may disagree with the judge's evaluation of that point, but in my respectful submission, there is no error of law. And my ladies, I'm sure will recall how Miller and Friend put his argument after submitting that there wasn't any consideration. Miller and Friend then submitted that there wasn't any evaluation or proper evaluation. Of course, this court is not, at least at this stage of the analysis, substituting its own view or reasons for the judge's analysis. Miller and Friend's second submission was an attack on paragraph 35 of the judge's decision. This is the point about the time in prison. And Miller and Friend gave a number of reasons as to why, in his submission, the view expressed by the judge at that paragraph was not justified. But when Miladies will consider their notes of the submissions that Miller and Friend has made, Miladies will see that Miller and Friend submitted that the judge held that when the appellant was in prison, quote his words, things were fine, and the wife managed okay. This, with respect, is not what the judge actually said. The judge wasn't saying that things were absolutely fine when the appellant was in prison or the mother managed okay. The judge is simply making a point that the mother was able to provide care and day-to-day support to the family and to access outside groups. Nothing more than that. And the judge at that point wasn't considering adequacy of the care and support that the mother had provided at the time. Now, if the judge's decision had ended at paragraph 35, there might have been good force in the submission that Miller and Friend makes. But that surely is not the basis on which the judge ultimately concluded that the consequences would not be unduly harsh. I ask you respectfully to look at the next few paragraphs 36 to 42. It is at those paragraphs in my respectful submission the judge actually gives reasons for the ultimate finding. Miller and Friend's next submission was about the COVID-19 website and paragraph 41 of the judge's decision. I've dealt with that in my skeleton argument. I have accepted that it is unwise for a judge to conduct post-hearing internet research. My respectful submission is that the alleged error is not material to the outcome, and it is for two short reasons. The judge at paragraph 41 accepts that the wife fell within the vulnerable group, but says that the website suggests that there is no greater risk of infection. This paragraph is immaterial. The alleged error is immaterial because Miller and Friend does not submit and did not submit before the judge that the wife was at a greater risk of infection. Secondly, my ladies, it is in my submission quite clear that the ultimate finding at paragraph 42, that the consequences would not be unduly harsh, does not depend on what the judge said at paragraph 41. So the alleged error, for these reasons in my submission, is not material.
So how do we know that it didn't take that into account? I mean, it doesn't say at 42.
So 41 says that, acknowledges that the uncontroversial fact that the appellant, that the wife fell within the vulnerable group, it is accepted, the judge said. So that is an uncontroversial fact. The judge then says that, well, the website suggests that there is no greater risk of infection. So what the judge has done, I accept, is unfortunate. But there is no issue between the parties as to whether the wife is or was at greater risk of infection. That isn't the point that my learned friend makes. So the reference to the website, though unfortunate, in my respectful submission, discloses no error of law that would justify setting aside of that decision. My learned friend then, ladies will recall, challenges what the judge said at paragraph 40 of his decision. This is the way in which the judge dealt with the expert evidence. Again, I've dealt with that point in my skeleton. I accept that if one looks at the first sentence of paragraph 40 in isolation, that would be objectionable. But I do respectfully say that the point does not assist the appellant in this case. If you look at paragraph 40, the first sentence, the words that I respectfully seek to emphasize are these words: there is also an issue for which an issue. The judge is not, in my respectful submission, deciding that issue in the case or resolving that issue against the appellant or rejecting the expert evidence because of that issue. And I entirely accept that this isn't something that one would ordinarily expect to see in a decision of this sort. If the judge had a conversation with another judge and the judge was aware of the criticism, perhaps that would be something in the mind of the judge, but one would not expect a judge to say that in the written decision. But all the judge is doing here is setting out what appeared to him to be an issue. Nothing more than that. If the judge had said, if the judge had not used those words and started paragraph 40 by saying that, well, the expert has been criticized by another judge, that the position might have been different. But
well, he clearly thinks it's relevant because he's put it in. So what is it relevant to?
Well, he, in my respectful submission, identifies an issue that was troubling him, but then decides not to decide that issue in that appeal, not to hold that against the appellant. When he did not say, for example, milady, that, well, I'm not accepting the expert's evidence for that reason.
Well, nor did he say I am accepting the expert's evidence anywhere. Did he? So we just don't know.
No, he has given reasons elsewhere in my respectful submission for not accepting the entirety of the expert evidence, and I'll take you to that paragraph in a minute. But just dealing with the second paragraph of that decision, which is again a sentence that my learned friend criticizes. the judge there makes a reference to what the expert said about the risk of suicide. All in my respective submission, the judge is saying is that, well, it wasn't helpful for the expert to refer to an issue that wasn't at large in the appeal. But you'll recall, you'll see that this paragraph appears at the end of, towards the end of the judge's analysis. If you look at paragraph 32, now he makes a different point about the expert report. Well, he says, and this is the point that my lady put to my learned friend when he was making his submissions. Well, the judge says that, well, the expert refers to some treatments, but well, it's an old report from October 2019. There's no update, no indication as to whether treatment has been taken and how successful or otherwise the same has been. There's no challenge to this part of the judge's decision. Now, if you then and as part of this point, my learned friend submitted that the judge failed to take into account N's diagnosis. That was the point that he ultimately made. Again, I respectfully take Milady's back to paragraph 29 of the judge's decision. This is where the judge refers, cites the relevant passages of the witness statement. And you will see that paragraph 7 of the witness statement deals with N and the fact that the N was suffering from separation anxiety and was under treatment. The judge then set out the relevant parts of the expert evidence. If you also look at paragraph 11 of the witness statement, this is just above paragraph 30 of the judge's decision.
Yeah.
So the judge clearly took that matter into account. It can't be said in my submission that the judge did not take that into account.
Well, he recorded it.
He recorded it. Where the judge dealt with it in the analysis is at paragraph 39. So the judge says that there's no suggestion that assistance interventions will not be available if required for both N and S in helping her deal with the emotional needs.
Who is AS there? Really AM or is it?
Sorry, NS.
NS is N.
Is N.
But there was also a suggestion in paragraph 7 of the mother's statement that the same thing was going to happen to S. And is that a reference to S or is it a reference to the wife?
Must be the wife.
Must be the wife.
Yeah. So nothing about the possibility of S having similar problems.
Yes, but so far as so you mean S, my lady?
Yeah.
You mean N, my lady?
He refers to N, but he doesn't refer to S.
Yes.
Yeah. Okay.
Yes, that is.
Yeah.
That is correct. Earlier, given that the lady has asked the question, earlier in the decision, this is paragraphs 39, paragraph 33, 34.
Mm-hmm.
The judge deals with the welfare of both children. Again, I respectfully submit that the ultimate conclusion is at paragraph 42. The judge said that, well, I've looked at all the evidence. I accept that it's going to be difficult, but not so difficult so to cross the unduly harsh threshold. The conclusion in my submission was open to the judge on the evidence. Now this takes me to the points of law that my learned friend makes.
Well, before you get there, what about the... she was just about managing with 2 children,
Yes.
and now she's got 3. Where do you say he properly engaged with the fact that she would have to manage with 3 children?
Well, when the judge was making the decision, the wife was pregnant.
Well, that's not going to last forever.
No.
So a realistic assessment surely has to engage with the fact that this is a mother of 3 children, bringing them up on her own, not just a mother of 2. And many of us will know the difference between 2 children and 3 children, even in a family with both parents.
My respectful submission is twofold. The first is that a judge is obliged in my submission to decide the facts as they are at the date of the hearing. I completely understand.
What,
my lady's-
ignore the fact that the baby's going to be born?
No, my lady, I completely understand the point.
Yes.
But I do emphasize that if there isn't, so the task that the judge was performing was considering whether deportation would be unduly harsh
Yeah.
on the 2 children and the wife. There wasn't a 3rd child at that point.
But the wife,
But the wife.
Yes.
her status was that of a pregnant woman.
Now, yes, and yes, so the judge, the reasoning in my respectful submission makes it plain that the judge, of course, knows that wife is pregnant.
Well, he definitely refers to it in the context of the strange COVID discussion.
Yes.
But does he evaluate it in the context of this finely balanced question of whether it's unduly harsh?
Well, lady, in my respectful submission, he does that at paragraph 42.
At 42. Okay.
And lady, the reason, and I've taken you to my skeleton and to the 5 propositions that I made in that document. Now, the judge's conclusion is at paragraph 42. Was the judge required to expressly identify every factor in the reasoning in my submission? No. And one may disagree with the judge's drafting style. Another judge might have given more detailed reasons. But the question for this court is whether there is a legal error. In my respectful submission, there is none.
We do need to be confident that he did take it into account, though, don't we?
Yes, if lady, you take the view that there was a failure to take a relevant matter into account, that means that the decision is wrong in law.
Yeah.
But in MA Sudan, Lady Hale made a point that where, this is paragraph 23 of my skeleton, MA Somalia, that where a point is not expressly mentioned, the court should be slow to infer that it hasn't been taken into account.
Yes, so we mustn't jump to the conclusion that he
No.
simply forgot about it or ignored it. But we do need to be confident that he did weigh it in the balance.
Absolutely,
Is that
yeah. I accept that. So the context is that the judge expressly records the witness statements, refers to the fact that the wife is pregnant, and the question for the court is whether, in that context, is it the case that the judge simply forgot about that matter when conducting the ultimate analysis?
To what extent is it relevant at all that in what you've accepted is, I think, fairly limited reasoning,
Yes.
there are 2 references to things which you've accepted and not would be better not made?
Yes.
So, whereas you have addressed those as individual points, is there a point about the overall decision which has arguably limited reasoning, and within that reasoning 2 points that perhaps would be better not made.
Well, if Miladies take the view that well, those 2 points were material to the outcome, Miladies will allow the appeal and set aside the judge's decision. But my submission is that those 2 points were not material to the outcome when one reads the decision as a whole. And I do of course ask Miladies to read the decision as a whole. The reasoning is limited, again, a point that I have accepted in my skeleton argument. But I invite Miladies to find that the 2 points, paragraphs 40 and 41, are not material to the outcome. Moving on and dealing with the points of law that Miller and Friend identified towards the end of his submissions. Now, Miller and Friend took the court to Hatche, Iraq, and says that, well, the judge applied the wrong legal test. In my respective submission, that plainly isn't the case. Now, if you look at paragraph 20 of the judge's, paragraph 22 of the judge's decision, the judge there refers expressly to A, Nigeria, and Hatche, Iraq. Paragraph 23, the judge refers to KO, Nigeria. And at paragraph 24 makes it absolutely clear that he knows that there is no notional comparator. Necessarily, and any of the 2 words that the judge has emphasized. And the judge then sets out the relevant parts of Hatche, Iraq. If you look at paragraph 24, within that paragraph 51, this is paragraph 51 of Hatche, Iraq, the UT, you'll see that the judge identifies the MK self-direction, that is, the
It doesn't set out paragraph 56 of what this court said in HA, Iraq.
That is true, milady, but see paragraph 53. Well, that makes the same point, that they cannot identify an objectively measurable standard, and one has to focus on the facts of each case. Then paragraph 152, you see that the judge knows that the resulting decision to deport a parent may produce hugely detrimental consequences for a child. This is that quotation, 5th last line, paragraph 152. The resulting decision to deport a parent may produce hugely detrimental consequences for a child, but provided his or her best interests have been adequately identified, the weight in the balance as a primary consideration, the decision will be lawful. That with respect is the case here.
You say they were weighed as a primary consideration.
Of course, yes. And I've accepted this in my skeleton, that it's uncontroversial that all children should reside with parents. Mm-hmm. I also accept that the appellant's deportation on the evidence would produce hugely detrimental consequences for the two children. But the judge was entitled to conclude that those hugely detrimental consequences on the MK threshold would not be enough. They would not meet the unduly harsh test. So this really is the context in which I invite Miladies to look at the 2 paragraphs that Miller and Friend referred to in his submissions, paragraphs 35 and 36. Mm-hmm. So when one looks at those paragraphs in this context, it becomes plain that the judge wasn't using a notional comparator. The judge wasn't saying in those paragraphs that the consequences would not be unduly harsh because those consequences are faced by every other family or every other child. Now I do want to take my ladies to Hatch Iraq just to show what was considered to be objectionable in that case and what a notional comparison actually looks like. So Hatch Iraq is tab 12.
Yeah.
May I take my ladies to page 256 of the bundle. This is page 1352 of the report. Just above paragraph 66, you will see a heading, Decisions of the First Tier Tribunal and the Upper Tribunal.
Yeah.
If you look at the next page, page 257, you'll see that you'll see that the entirety of that page is a lengthy quotation from the Upper Tribunal's decision in that case.
Yep.
If you look at 70, you'll see it then says, so this is the decision of the Upper Tribunal in that case, that was found to be wrong in law by the Court of Appeal and the Supreme Court. If you look at paragraph 71, so the Upper Tribunal in that case said that, there was no evidence that the detriment would be anything other than which is ordinarily to be expected by deportation of a parent, of a partner parents. So that is a true notional comparison. The judge knows, Judge Henson knows that that is not permissible. He knows what the court has said in Hatch Iraq. He does not say at paragraphs 35 and 36 that the consequences would not be unduly harsh because they are not anything other than which is ordinarily to be expected by a paradigm deportation case. What he is actually saying at paragraphs 35 and 36 and in all subsequent paragraphs is that, I've looked at the circumstances, considered the welfare of the children. I accept that things are going to be difficult. Things are going to be harsh. See paragraph 38 in particular. The judge said, I accept the deportation will result in harsh consequences for the family unit. Judge is saying, that is not enough on MK threshold. So there is no misdirection in law by the judge in my respective submission. Miller and Friends' final submission, again, it raises a point of law as to whether rehabilitation is relevant in considering Section 117C(5) of the 2002 Act. And the way in which Miller and Friend put his submission is to say that, is it unduly harsh to deport someone who has taken steps to address the offending behavior? Miller and Friend says that that is something that is relevant, and the judge was obliged to take that into account in deciding whether consequences would be unduly harsh. Well, this submission, there are two difficulties with this submission. The first is that it is directly inconsistent with the natural and ordinary reading of Section 117C(5) of the 2002 Act. And secondly, it is irreconcilable with the case law and produce some odd results. Now, dealing with the 2 points in turn, you have Section 117C(5) set out in the skeleton arguments in the decisions. Behind tab 2 of the authorities bundle, ladies have seen that the entire focus of that provision is on the children and the partner. The question isn't about undue harsh consequences for the person who is facing deportation. The fact that he has taken steps to address the offending behavior is simply irrelevant because that concerns that person alone.
Does the same explanation apply to why it's not relevant to consider the seriousness of the offending?
That's my second point, my lady. So the consistent case law, and I'll not take my ladies to the authorities, I've set out the authorities in my skeleton. So KO Nigeria, where the Supreme Court said that when considering the exception, the unduly harsh exception, a person's criminal conduct is simply irrelevant. Hatch Iraq is the same, and the reason, milady, is one that milady has just identified. So if a person's criminal conduct is irrelevant, why, I ask ladies to consider, rehabilitation can be said to be relevant. It would surely be odd if criminal conduct is, if the actual offending is irrelevant, but steps taken to address that offending are deemed to be relevant. My learned friend took miladies to Hashim Ali, and he submits that judgment supports his proposition. There is, with respect, nothing in Hashim Ali that provides any support to this particular proposition. It is manifestly clear with respect from paragraph 2 of that judgment. So that judgment is behind tab 9 of the authorities bundle. And if you look at page 127, paragraph 2, Lord Reed said in the last sentence, it is unnecessary to consider most recent amendments to the legislation, including those affected by the Immigration Act 2014. Section 117B was inserted in the 2002 Act by the Immigration Act 2014. So this judgment, with respect, has nothing to do with undue harsh test. This concerns the regime that was in place before Section 117B and Section 117C came into effect. And this takes me to a question that milady you asked when Bilal Friend was making his submissions, that paragraph 38 refers to paragraphs 399 and 399A of the immigration rules, and those provisions relate to unduly harsh test. Well, the paragraphs 399 and 399A were completely different at that time. So if you wish to see those paragraphs as they were at the relevant time, they are at page 133.
In Hashim Ali.
In Hashim Ali, yes, paragraph 23. You'll see that paragraph 399 appears towards the end of that page. The question then was whether there was a subsisting or genuine parental relationship, whether the child has resided in the UK for 7 years, whether it's reasonable to leave.
Okay, so no reference to unduly harsh in those paragraphs.
No. So the unduly harsh test was inserted in the legislation by Immigration Act 2014 when Section 117B and Section 117C were inserted in the 2002 Act. So at the same time, immigration rules were amended. So the current version of the immigration rules was amended when those provisions took effect. This judgment has nothing to do with the unduly harsh test. In any event, it's quite clear that paragraph 38, the point that Miller and Friend makes, concerned very compelling circumstances, the overall balancing exercise. Miller and Friend then makes a submission that, well, it can't be right that rehabilitation can be taken into account when it comes to serious offenders, but cannot be taken into account when it comes to medium offenders. Well, that too, with this practice, is not correct. So, Section 117C6, which is the very compelling circumstances test, that applies not only to serious offenders but also to medium offenders. The Court of Appeal made it plain in HA Iraq. The Supreme Court agreed with that. That's based on this court's judgment in NA Pakistan, and that really is the reason why this judge
Dealt with it under.
dealt with it. Yes. So it isn't the case that rehabilitation is relevant only when it comes to serious offenders. So the judge, with respect, was absolutely correct in not considering the issue of rehabilitation in deciding whether the first exception was met, the second exception was met. This takes me to the point that my learned friend makes, that, well, the judge's assessment of rehabilitation in any event was wrong. I, of course, accept that amended grounds have been filed and permission has been granted. If you look at the amended grounds, my ladies, this appeal is about the unduly harsh, the judge's conclusion as to the unduly harsh test. Unless I've missed something completely, the grounds do not attack the judge's assessment of proportionality outside that exception. So it's questionable whether the point is open to my learned friend. But the answer with respect is in my skeleton argument, if you look at paragraph 33 of my skeleton argument, you'll see that I have summarized the key conclusions reached by the Supreme Court in HA Iraq by reference to the very compelling circumstances test. And if you look at the second point that I made in that paragraph, this is page 11.
Yeah.
That relates to rehabilitation. Court made it clear that it's where the only evidence is that a person hasn't committed any further crimes, that is likely to be little or no material relevance to proportionality assessment. It then makes the point that, well, if there is substantial positive evidence, well, that only goes to one element of the public interest, protection of public from further offending. But deportation has two elements. There are two elements of public interest. First, of course, is protection of public from reoffending. The other is deterrence. Rehabilitation has nothing whatsoever to do with the deterrence element. And if you look at the judge's decision, you'll see that he considers the issue of rehabilitation in the context of the strong public interest in the appellant's deportation. So when it comes to an assessment under section 117C6, very compelling circumstances, and one has to take into account a range of relevant factors. So earlier in the decision, the judge had concluded that there were no very significant obstacles to the appellant's integration on return to South Africa. This is paragraph 20. So that is the context in which one then looks at the Article 8 assessment, paragraphs 43 to 49. The judge recognizes at paragraph 45 that the appellant falls within the medium category. The judge at 46 accepts that, well, it's never pleasant for a child or a partner to be separated from a person who's facing deportation. And then says, paragraph 48, that there is a very strong public interest and there aren't any very compelling circumstances over and above the two exceptions. So even if the point is open to my learned friend, in my submission it discloses no error of law. This surely, with respect, is not a case where the only where the appellant's success is inevitable.
Well, hold on. If there is an error of law and we're into the territory of either remaking
Yes,
or
you-
remitting, you say the outcome of that exercise is not inevitable.
Absolutely, yes. But I do. You have my premise.
You say there's no error.
There's no error
This
of
is
law.
a
Yes,
perfectly acceptable decision.
absolutely. And if one looks at the terms of the statute, this is Section 14 of the Tribunals Courts Enforcement Act 2007. So the task of this court is to decide whether there is an error of law. If the court concludes that there is an error of law, there is then a discretion. The court can still dismiss the appeal. The court is not obliged to set aside.
Well, if there's
Yeah.
a material error of law,
Precisely,
then we are obliged to
Ab-
set it aside.
Absolutely.
Sorry,
That was the
okay.
point that I was seeking to make by reference to the statute. So the fact that there is an error is not enough. But if there is an error that is material to the outcome, then the decision goes. But if that is the conclusion that the court reaches, then I respectfully submit that the case should be remitted to the Upper Tribunal. It is, in my submission, noteworthy that my learned friend has not challenged the Upper Tribunal's decision on the grounds of irrationality or perversity. So he's not saying, in challenging the Upper Tribunal's decision, that, well, the decision is irrational in the sense that, well, no reasonable Upper Tribunal could have dismissed this appeal because the outcome is inevitable. His challenge is to the reasons, failure to take relevant matters into account, and that surely means that there is a room for a different outcome. My learned friend also suggested that the court can perhaps remake the decision on the basis of findings of fact made by the First Tier Tribunal, but the First Tier Tribunal's decision is surely gone. It has been set aside. There's no appeal from the Upper Tribunal's decision to set aside that decision. So it wouldn't be appropriate in my submission for the court to make a decision on the basis of those findings. One final point which I've made in my skeleton, that the Upper Tribunal made its decision in 2020 and said that, well, the evidence was from 2019, we are now in 2023. It wouldn't be, in my respective submission, an appropriate exercise of discretion to make a decision without updated evidence. So unless I can insist any further, respectfully invite my ladies to dismiss the appeal on the basis that there is no material error of law, or alternatively to remit the appeal to the Upper Tribunal.
Thank you, Mr. Malik.
Thank you.
Anything else? Thank you very much. Well, we recognise. Oh, I'm so sorry. Yes, sorry, Mr. Ball. I do apologise.
No apology required, my lady. I'm mindful of the time, and I'm confident. that
No,
I can
you've got
deal with us
time.
before lunch.
There's no hurry. There's no pressure. I'm so sorry. I
No.
don't know what possessed me.
Probably 2 barristers all morning. If I can deal with my grounds, taking my third point first. So my third point is the argument that the judge either applied the wrong test,
Yes.
or he applied the right test and gave insufficient reasons. Mr. Malik drew the court's attention to the section of the judgment where the judge reminded himself of what was said in HA Iraq. Mr. Malik went a step further and said that the judge was reminding himself that there is no concept of a notional comparator required. I'm not sure that actually the judge goes that far, and as the court has observed, paragraph 56 of HA in the Court of Appeal, and it touches on that. I mean, it's actually developed in the concept of a notional comparator is developed in the Supreme Court's decision, which wasn't promulgated at the time of this decision. But the short point is that, respectfully, the learned judge may have recited elements of HARR, but the question is, to what extent did he then apply them?
But do you accept he gave himself an acceptable self-direction?
Yes, I mean, he reminded himself properly
Yeah.
of various paragraphs in HARR.
Yeah.
He didn't include the paragraph which I principally rely on.
Yes, although 53 does reflect the point, not in as much detail.
Yes, but the real question is, having directed himself, to what extent did he then apply it?
Yeah.
And I don't wish to repeat the submissions, but I simply say that in those sections of his judgment where he says there are others with worse conditions than you and their families stay together, that is where he has fallen into error. The error precisely identified by the Court of Appeal in HARR. I don't propose to address you any further on my submission as to unduly harshness, taking into account the concept of rehabilitation. In my submission, I have better points than that. So I concentrate my submissions.
You're not abandoning it, but you're not...
I'm not pursuing it with any vigour. Because, as Mr. Malik himself accepts, A, this judgment has relatively short reasoning, but B, he accepts that there are repeated errors in that reasoning. And those two issues do not sit well together. And in particular, under my first ground, failing to take into account relevant factors, I pray and aid the fact of the pregnancy. And Mr. Malik says in one breath, well, that was obviously taken into account by the Upper Tribunal judge. See paragraph 41. That is the sole reference to pregnancy. So he says that on the one hand, and then on the other hand, he says paragraph 41 contains an error, but it is not a material error. Well, which one is it? Is paragraph 41 central and displays that the Upper Tribunal judge fully considered the impact of pregnancy, which is what the Secretary of State's first submission is, or is it actually defective? Well, the reality is that, respectfully, I am right on both fronts. Firstly, the judge has failed to take into account the pregnancy as a relevant consideration, and secondly, when he has referred to the pregnancy in the context of COVID, he has fallen into error by going away doing his own research. In argument, it was put, or it was tentatively suggested by Mr. Malik that, okay, at the time the judge was considering this, there were only 2 children, and the judge was considering the case before him. If I could invite you to turn up HARR again, hopefully for the last time, and in particular at page 260 of the Appellant's bundle.
This is in the Court of Appeal again.
Sorry, yes. Let me just... paragraph 75 at the end, we mentioned the last 4 lines up from the bottom, real world facts. We mentioned the line of authorities which establishes that tribunals must make decisions in the light of the real world facts. As my lady has properly observed, the appellant's wife was not going to be pregnant forever. So the judge has failed to properly take into account the pregnancy. And then on the question of practical and emotional support, observations have probably been made as to how is this family going to manage financially and to what extent has the judge taken that into account. And Mr. Malik again relies on paragraph 39, where he says, in my record of his submissions, that is where the judge was properly considering the practical arrangements. Well, that is not what paragraph 39 says. Paragraph 39, the children currently reside with their mother. There's no suggestion this will change. It's not made out. Assistance and interventions will not be available if required for both NS in helping her deal with her emotional needs, or AS, that's the mother, in relation to any personal or parenting issues. Well, I do not take personal or parenting issues to encompass the financial insecurity that is obviously going to beset this family by losing the main breadwinner. And it is an apposite for the Secretary of State to rely on that paragraph as representing a clear account of a judge having regard to the relevant factor of the absence of practical support.
Well, the practical support, Mr. Malik said, is addressed in the paragraph where he deals with, he talked about going school.
The school run.
Yeah. What was that?
Yes.
36? No.
Yes, 37.
37.
Yes.
You say he doesn't cover financial.
Yes. And you have my observations on the issues in relation to the judge's treatment of the support network point. It isn't properly addressed. And Mr. Malik takes you to various paragraphs, 35, 36, 37, 38, 39, 42, in which he says, looked at in the round, it is dealt with. Well, I, and no doubt this court, have looked at those paragraphs extensively, and it doesn't adequately or at all head-on engage with the unchallenged evidence that there is no way I can raise them on my own. Secondly, then, and finally, my limb relating to the judge's treatment of the evidence, both the COVID point and the Tamara Licht point. Well, I've already highlighted how it's not in the Secretary of State's gift to say that on the one hand, paragraph 41 is not a material error, but on the other hand, we rely on that as central to the suggestion that the birth has been taken into account. It can't be both of those. But the point here is that the Secretary of State cannot sidestep all this and say that the post-judgment research is unfortunate, but it is not a material error. It is unfortunate, as acknowledged by Mr. Malik, because it is unfair. And it is the unfairness which means that it, in and of itself, amounts to a material error. And then Mr. Malik effectively uses the same line in relation to the observations of Tamara Licht, effectively saying again, well, there's some unfortunate commentary in there, but looked at in the round, it's not material. The judge wasn't actually deciding an issue about that, so it's neither here nor there, but the judge has got some unreferenced criticism to the expert. You cannot take a blue pencil and say, well, we'll ignore this sentence in the judgment and exclude that. The judge was obviously setting out an issue which troubled him. And what we simply don't know is how has he actually treated the evidence of Tamara Licht? What is he accepting or rejecting in relation to the diagnosis? What is he accepting or rejecting in relation to the things that follow from the diagnosis? All we have instead is what I would characterise as somewhat disparaging remarks, which obviously have been included to some extent to reflect an adverse view of weight taken by the judge. But in as far as they do that, they fall into error. And that's why one can't simply compartmentalise these errors, as the Secretary of State seeks to do, and say, well, yes, it's unfortunate that he went away and did post-judgment research. It's unfortunate that he made these unreferenced comments about Tamara Lex, but they're not material. Because one has to look at it all in a round, and central in this case was, what is the impact on N? Is it unduly harsh? How are they going to manage the absence of a support network? And these questions simply haven't been properly addressed. And when one compounds that with the concerns surrounding fairness, this is a case in which, in my respectful submission, you may consider the appeal should be allowed, unless I can assist you further.
Well, thank you very much. Thank you. Thank you very much. I don't think it will come as a surprise to you if we reserve our judgments. We are conscious of the fact that this is a case of great importance to your client and to his family, and we will do our best to get a judgment to you as quickly as we can. But I'm afraid I can't make any promises about how long that will be. When we do circulate a judgment, it will be for typographical errors and corrections and not for receipt of further submissions, and you will of course bear in mind the important warning about contempt. Thank you both. You've addressed us both in writing and orally in very cogent and persuasive submissions, and we're very grateful for your assistance. Thank you.
All rise.